Hello, everyone. Good morning, or good afternoon, or good evening. A very warm welcome to all of you on behalf of BDVA's Task Force 5 on policy and societal topics, and on behalf of my colleague Charlotte Ducoin and myself, who will be your moderators for this session. A session that put forward a question, whether fairness can be a tool for legal interoperability in the data economy. So two important components, and the concept of fairness and the concept of legal interoperability. And we've set as objectives for the session today to discuss some different perspectives with regards to those concepts, to give insights on the rationale behind the introduction of fairness in many legal and non-legal frameworks, and to take first steps towards operationalization of these concepts. And to reach these objectives, we've also designed an approach that also contains two important components. First, a fantastic lineup of speakers that we have brought together for you today. And second, it's you. It's all of you in the audience. I hope that you will all agree with us that this is an important debate. And so please engage. Please put your questions in the chat. And you're already familiar, seeing that we are as advanced in the event, so you're familiar with the chat of the B2Match. Please put your questions. We will have a second part in the workshop that is a roundtable with our speakers here, and that contains the important contributions from your side. So please, we welcome all of your questions in the chat. So as a first contribution, I would like to now hand the floor to my colleague, Charlotte Ducoin, who will set the scene for this workshop. Thank you all, enjoy, and Charlotte, you have the floor.
Thank you, Nathalie. I can only relate and say how happy I am to be here with you today, and I hope you will all get a good understanding of the topic here and get triggered into thinking about how this notion of fairness translates into concrete obligations, actually, in recent legislative proposals from the Commission in the data environment. So here I'm just very briefly setting the scenes to make sure that we all know what we're talking about and actually to raise the questions in the first place. So the notion of fairness has made its way to at least three recent legislative proposals in the digital environment. So I'm only skimming through. So first, the Digital Markets Act, well, it's in the title. The purpose is to establish contestable and fair markets in the digital sector. We know the problem with big tech and so on. And fairness comes again in the form of an obligation incumbent on gatekeepers who are basically under friends, so to speak, obligations to provide fair, non-discriminatory conditions for a number of things. So for ranking, we know it's been an issue for some time, for access to search engines, and also for access to app stores to the benefit of business users. And then fairness comes again in a different setting, applicable to the European Commission, who has as per the proposal of the Commission at least, the possibility to either suspend or exempt some of the obligations applicable to gatekeepers in certain conditions. And there we have fairness appearing, so that the European Commission should make a fair balance between the objectives that are here in the text and other interests especially of gatekeepers, which could stand in the way of these obligations, so that the Commission could say, okay, then for some time you are exempted from these obligations, or we suspend those obligations. So here we have basically two types of fairness. The first one, as I said, seems to be quite inspired by competition law remedies. I'm not going into the details. And the second one, well, is different. It applies to the European Commission and not to private entities. And here it's clearly staged as a means to balance conflicting interests. Then in the Data Governance Act, we have one occurrence of fairness with respect to the regulation of data sharing service providers, so data intermediaries. And again, it's quite similar to what we have for gatekeepers. So it's some sort of a friends obligation. They should provide access to their services in a fair, transparent, non-discriminatory manner, which includes prices for their services. And here, well, as you might already know, the legal regime applicable to data sharing service provider is extremely strict. So you could even wonder whether it's actually heading towards the direction of some sort of public utilities, actually. Then, last but not least, in the Data Act proposal, we have many occurrences of fairness, which the European Commission recounts even in the title. They want to set rules for fair access to and use of data. Then we have something very weird, in my opinion, in chapter 3. So chapter 3 is about setting lex generalis rules applicable in case of data sharing obligations. So some of those that are in the Data Act, but mainly those that could arise from future regulations, such as data spaces regulation. And there, again, you have this friend regulation that data holders who have such data sharing obligations should make data available on the fair, reasonable, non-discriminatory terms. And we have a dispute settlement body that's here to substantiate fairness where parties can't agree. So here, what is very strange is that you don't have, well, you could have data sharing obligations for a number of reasons, stemming from different rationales, which may have different understanding of the notion of fairness. But here you have absolutely no explanation how you should interpret fairness. And finally, we have something maybe more common. In chapter 4, we have regulation of B2B unfair terms to the benefit of SMEs. And then we have something that looks like a bit consumer law regulating unfair terms, with a blacklist of unfair terms, a gray list of terms that are presumed to be unfair, and then, sorry, the general provisions that terms are unfair and prohibited if they grossly deviate from good commercial practices in data access and use, and contrary to good faith and fair dealing. So I'm through. We see that we have a lot of different occurrences of the term fairness, probably with different meanings. And we, Natalie and I, thought it's useful to ask ourselves the question, how do we operationalize such obligations? And in doing so, we will start with a step backward, looking into the background of where this all comes from, because it's not entirely new. So yeah, I'm not directly giving the floor to Damian Clifford because Natalie will introduce him, but basically that's his much appreciated intervention here. Thank you.
Yes, thank you very much, Charlotte, for giving us this important overview of the recent legislative proposals in the digital environment and for already providing us those triggering questions. And indeed, as you said, we are taking a step back, not really a step back maybe, but indeed also referring to other legislative frameworks like GDPR and consumer law, where we also have the reference to the principle of fairness. So it's my real great pleasure to introduce to you and to welcome here Dr. Damian Clifford, Senior Lecturer at the Australian National University College of Law and Chief Investigator of the ANU Humanizing Machine Intelligence Grand Challenge Project. Damian, thanks for being here. You have the floor.
Thanks, Natalie. Just share my slides and get started. Okay, so hopefully we should be sorted. Yeah, so as Natalie and Charlotte alluded to, I mean, we're going to take a step back. But I suppose, well, back maybe not the correct word. I'm going to discuss fairness and data protection, and then speak about how there are complications when you look at the overlap between different notions of fairness when you also look at, say, consumer law. So my fascination, if I can get slides to work, with fairness in data protection kind of largely stemmed from the fact that it was always positioned as a core principle of data protection without much elaboration beyond that. So I have, I suppose, two sources on the slide there kind of discussing this core or central positioning of this principle. You have the European Data Protection Supervisor noting specifically that it is a core principle of data protection alongside lawfulness and transparency. And you have, say, Lee Bygrave with a particularly interesting quote saying that it embraces and generates the other core principles of data protection laws. And that was kind of the starting point for my interest in it. There was surprisingly little written about it, although it was kind of alluded to in a lot of literature and court decisions and interpretive guidance coming from the different authorities. There wasn't really any great discussion of what it actually was. So on that basis, I've written a few things, and I'm kind of putting that up there because I suppose the first of those was a co-authored piece. So I have to acknowledge that it wasn't my sole contribution to the literature. So it was a paper that I wrote initially with Jeff Ausos, who is now at the University of Amsterdam. But I've also written more recently on this in a bit that's forthcoming, which I think is a little bit more digestible than my initial attempt at this. But it kind of points, I suppose, at the complexity of this topic and what it actually, I suppose, trying to discover what it means. So what I thought I would do as a kind of a general scoping of what the presentation will contain is to first kind of start out by noting where it actually is, where it's mentioned, yeah? So Article 8.1 of the Charter of Fundamental Rights lays out the right to data protection, and Article 8.2 then and 8.3 specify further conditions related to that right. What's important for our current discussion is that fairness is directly mentioned or specifically mentioned in Article 8.2, and that's in addition to what's contained in the GDPR itself. So there is a fairness principle that I suppose any data protection scholar will be aware of, but like there are these two mentionings. So it has a fundamental rights kind of grounding in a specific reference in the right itself, but it also has this other mentioning in the regulation itself. Now there are other places that it appears in the GDPR, but that's the primary place. So what I'm going to do is I'm going to kind of take you through what I think each of these means, or what they could mean. Yeah, so what it kind of potentially could mean within the context of the charter, what it potentially could mean within the regulation itself, and then in the third part, I'm going to show you some takeaways that I have, or confusions maybe, how confused I am by this topic, despite looking at it for quite a long time now, and then I'm going to take you through an example of why it matters. And that's kind of the remaining subparts there in part 3. We'll see how we get on in terms of the timing. So I'm happy to be interrupted if I'm kind of going on too long. Okay, so with Article 8.2, now, despite being specifically alluded to, it's very difficult to actually figure out what it actually means, this reference. And that kind of largely stems from the fact that there are different interpretations of the construction of the right to data protection. Now, a lot of this, I suppose, is fairly high level, and I'm happy to share the slides afterwards with anyone or some of the other stuff that I've written. But I just wanted to put it out there, and you can look at this afterwards, that there are different constructions and understandings of the right, and some people would say that fairness actually goes to the core of the right to data protection. So you've Hilke Heymans there listed on the slide, is basically saying that the right itself can be characterized as fairness, checks and balances, that it goes to the very nature of the right to data protection. There are others, I suppose, such as Fuster and Gertwit, who are saying that fairness is just one of the elements that could be considered. You have to look at all these things that are listed in Article 8.2 and Article 8.3 in order to figure out what data protection as a right is actually about. And those approaches then would contrast with other approaches to the interpretation of the right, which see it more as informational self-determination. So we already have a certain conflict within understandings in the very, I suppose, core meaning of fairness within data protection from the understanding of the right. Now, in addition to that, we have a significant overlap with what is known as Article 52.1 of the Charter. So it could be also important in this context because this article essentially requires a fair balance between competing rights and interests where a right is being limited, essentially. So if we look at Article 52.1, so this is a requirement generally, I suppose you could see on the legislator to act proportionally when you're interfering with a right. And there's lots of key case law of the Court of Justice of the European Union dealing with the need to balance fairly different rights and interests when adopting legislation, and we have failures to do so, and then the striking out of legislation because there wasn't a fair balance struck in the legislative process because of that. So again, there are some examples on the slides there, and in the notes section, I'm happy to share with anyone there's specific references to some specific cases. So like when we think about it like that, we've got a specific mentioning of fairness within the right itself, but we also have this obligation to fairly balance rights and interests in the Charter more generally. And those rights are actually include the right to data protection specifically, but also other rights. So on the basis of that, then we could see that the GDPR could be construed as a system of fairness checks and balances, trying to comply with Article 52.1. So the European legislator, when acting, has to adopt legislation to essentially strike a balance between these competing interests, and that's what it's obligated to do. Yeah, so there we have, I suppose, the GDPR as this system of fairness checks and balances itself. So it's a manifestation of fairness, you could say. So another interpretation of it, which I think kind of points to some of the things that Charlotte was saying earlier. So now within this checks and balances, it's specifically noted in the GDPR, for instance, that it's there to protect rights and interests in general where personal data are processed. So you could say the right to data protection in particular, but also other rights and freedoms in order to create this kind of complex balancing of different rights and interests in the operation of the framework. So the whole thing could be construed as a system of fairness checks and balances. But obviously part of that balance then, to add further complication if you're not already confused at this point, is that the fairness is also specifically mentioned in the regulation itself. So fairness is part of this balance. So here we have, again, I'll just put it up, Article 5.1a, where it says that, fairness is something that should be protected. So it's understood as a principle in the framework. So when I was reviewing the literature on the GDPR and trying to traipse through it, again, recently for the piece that that's forthcoming, you could see fairness mentioned alongside lots of notions. So you have the reasonable expectations of the data subject, you have proportionality and necessity of the processing, you have the reference to the need to counteract inherent imbalance in asymmetries, and you have the need to mitigate against harmful or discriminatory effects of when processing personal data. So there, I suppose you have mentioning what something is very similar, I suppose, to what is contained in Article 52.1. So the proportionality and necessity, the need to respect other rights, like the right to privacy, where you could see language like the reasonable expectations of an individual to privacy. You could say that there's a link to non-discrimination, for instance, or equality with the discriminatory effects, and the need to create a balance there. So there seems to be a massive connection between fairness as it is contained in the specific framework and the broader obligations to act fairly on the EU legislator to fairly balance rights and interests when adopting a piece of legislation. So there's a huge overlap between the two of them, is essentially what I'm saying. They effectively seem to mean the same thing, but they're at different levels and the obligations are in different entities. So one is on the legislator when acting, and then the other is on the data controllers or the processors when they're processing personal information and trying to comply with the GDPR. So on top of that then, there's also a bit of confusion in how you understand the principle as it's constructed. So if we take a deep dive into the regulation just very briefly, we can see Article 5.1 of the GDPR, and we can see that it's listed amongst other principles. Now, all of these principles, I suppose the point I'm trying to get across here is that it's not entirely clear the relationship between lawfulness as a principle and transparency as a principle. And in fact, whether they are three distinct principles, whether they're one principle, whether they're kind of two principles, or what's going on really. Because you have, if you look at the other ones, they're a little bit more certain in terms of this kind of generally one principle kind of listed. So this interaction between lawfulness, fairness, and transparency is also quite ambiguous in terms of the construction of the regulation. Now, I would say that there's a distinction between formal compliance with transparency and something being fair and transparent, for instance, because you can be completely transparent about something, but that mightn't make it fair. So my own view in this, and I think it kind of reflects the general community, is that these are three different and distinct principles. And that also is reflected in terms of the operation of the lawfulness principle. So if you think about the different conditions for lawful processing, for instance, in a business to consumer context, you're largely looking at the ones with the stars next to them. So consent, contract, and legitimate interest. You could see how, fairness could play a role in the operation of those. So I'm going to give consent as an example later. But also you have a broader application of the fairness principle because there's also an interaction with the operation of data subject rights. So the operation of these data subject rights also has to be fair. And you can see that in the guidance literature as well. So on screen is a reference to the European Data Protection Board's guidance on the data protection by design and by default opinion, basically saying that it's an overarching principle that has its tentacles right across the GDPR and plays a role in the operationalization of all the requirements, essentially. So, it is extremely significant, but then we have no real test, no precise understanding of the contents of it. It seems to overlap significantly with the requirement for the EU legislator to fairly balance things, but then kind of shifts that responsibility onto the shoulders of those coming within the scope of the regulation, even though the regulation itself is a manifestation of the legislative desire to create a fair balance. Okay. So some takeaways. The first one is fairly obvious. It's complicated. I think it should be kind of clear by now that, or at least, I know if I've done a bad job of explaining it, it probably explains that it's complicated anyway. It's also context dependent because like what's fair depends on the specific context. So it creates kind of uncertainty in that sense as well because it is principle driven. And we don't know exactly what it means. It seems like a bit of a kitchen sink kind of a thing to it, like, so if all else fails, it might be unfair. So we can kind of just put that in there. And then it seems very connected, as I said, to the charter or the right to data protection more specifically. And it's hard to kind of tell the relationship between those two things apart. So the relationship between Article 8 and Article 52(1) of the charter. Yeah. So it is complicated. Now, this kind of then leads me to the next little bit, assuming that I've still a little bit of time, to discuss, how this kind of affects interoperability between different types of frameworks. So I've done a nice bit of work with Inga, actually, who's going to speak in a bit, on the overlaps between different frameworks in, consumer protection law, competition law, and data protection, and how fairness might overlap between them. Now, I'm not going to go into a huge amount of detail, but I just want to kind of show some difficulties, and in particular around consent. So consent in the GDPR is defined as outlined there. So any freely given, specific, informed, and unambiguous indication of the data subject wishes. The consent is required in a whole range of circumstances. Now, the framework itself isn't consent-based, but for anything that's kind of high risk, generally consent seems to be the basis, particularly in a business to consumer context. Yeah, so if you're trying to process sensitive or personal information, consent is one of the exceptions, or rather explicit consent. If you're trying to do automated individual decision-making, consent is one of the ones that's there as well, again, so explicit consent. If you're trying to use cookies, you're looking at the overlap between e-privacy and GDPR, but long story short, for non-functional based cookies, you're essentially required to use consent as well. So we can see that it has a key positioning within the framework. And a novelty of the GDPR was the introduction of this Article 7. So essentially, it was part of that fair balance that was struck by the legislator in order to create a fairer environment in which you could consent. So more optimal conditions for consent to actually operate, yeah, and be meaningful. Now, the one that I'm going to focus in particular on is Article 7.4, because I think it's interesting and it shows the intersections with consumer law a little bit more clearly. So Article 7.4, in a nutshell, to my eyes, more elucidates this notion that consent needs to be freely given in greater detail. So it is often read in combination with the non-binding Recital 43. Now I say non-binding because that's important. Recitals are there for guidance purposes. I suppose they have some effect, but they're not the binding provisions of the regulation. But essentially, if you read these two together, you can come to the conclusion that essentially holding access to a service hostage to consent, so you have to consent to access a service, could be deemed to be against the notion of freely given consent. And there's been a lot of debate as to whether this is the case or not. And it's obviously still filtering through. On top of that, another interesting provision was the Recital 42, which essentially says that for pre-formulated declarations of consent, you have the overlaps and intersections with the unfair terms regulations. So that's an unfair contract terms regulation. So it applies between business to consumer contracts specifically, and there are tests for fairness in there, essentially a substantive one and a formal one that you have to comply with. So it says when you're relying on pre-formulated declarations of consent, that this other framework actually applies as well. And I want to kind of discuss the implications with that, the overlaps between consumer law and the GDPR, and also point to the role that national law will play just to further complicate it again, okay? So when you're looking at Article 3, for instance, of the Digital Content Directive, which is a relatively new directive, the balance that was struck by the EU legislature in that context was to essentially say that when you provide personal information, when you consent to the giving of personal information, essentially, that results in the formation of a business to consumer contract. So it seems to be relatively inconsistent with the balance that was struck in the GDPR, or at least people have pointed that out. So what's precisely going on here? On top of that, then, to make matters more complicated, is that you have an assumption within this that there is actually a contract formed, because national law actually is important in the application of this. You have to refer to national law in order to figure out whether a contract is actually formed. So you end up with this kind of smattering of different rules that you're trying to squeeze together that have all been kind of, created by the legislator, with, I suppose, the idea of balancing different interests, but going at it from different angles. So with the Unfair Terms Directive, for instance, it's uncertain as to whether it will always actually apply in the context of pre-formulated declarations of consent, because you have to refer to national law to figure out whether there's a contract at all. Yeah, so it depends on there's a lot of uncertainty between these different overlapping notions of fairness and whether they can actually always apply in the same context, and also the fact that they have very different starting points. With the GDPR, it seems very grounded in fundamental rights and the Charter. With the Unfair Terms Directive and other similar pieces of legislation, there's a far more contractual economic nature to it, where, for instance, in the context of the Digital Content Directive, you have data, personal data, being positioned almost like as the price that has to be paid for the operation or the entry into the contract. Okay, now I think I probably might be close enough to time, so I can leave it at that, or I can give another example, but I'm just one sec, I'll just see if I have 5 minutes. Okay, so I'll give one more example maybe, and I'll see how I get on. So I thought that, so this is an example that I'm developing in another paper as part of an edited book that I'm doing with colleagues. You can see the reference below. So again, this is co-authored work, so I can't take full credit for it. But the idea is that we're looking at the intersection between national law, consumer law, and data protection law around the formation of a contract. In particular, we're looking at it through the common law lens. So I suppose, particularly in the context of the European Union, we'll be looking at Irish law and how they're actually going to make this work. With that, then we're taking certain examples. So the example that I have on the slide is if you take the example of a publicly accessible website requiring a login, and how you get these frameworks actually operating together. So, you know, in a data protection context or consumer law context, you know, it's quite possible, for instance, that any such website would be using cookies or some form of third-party tracking, even if that's kind of been phased out these days. So under EU law, you'll probably end up with some form of consent. Now, with the Digital Content Directive, you probably, according to that, you should end up with some sort of the formation of a consumer contract, and you'll end up with the application of the Unfair Terms Directive as well. Now, within when the Digital Content Directive, for instance, was being adopted, you had this discussion between the distinction between passive and active collection of data. So things like cookies were sought to be passive, and you know, actually manually inputting, say, creating an account was seen as active collection. Now, in the final version of that directive, that was removed, but it kind of shows you, I suppose, the different ideologies behind the pieces of legislation. One, as I said before, was more contractually focused and essentially trying to create fair market conditions, whereas you know, any potential inconsistency that could be seen with data protection law, as I presented earlier, would had a much stronger connection to the requirement to create this fair balance evident in the Charter of Fundamental Rights of the European Union. Now, what makes it even more complicated is, in this particular example, if you take that, you know, a publicly accessible website requiring a login, even if you're required to consent to the gathering of cookies, and under normal interpretation of the Digital Content Directive, that results in a business to consumer contract, you have to refer to national law in order to figure out whether it does. And there you have more process-orientated or procedural-orientated rules around fairness as to whether a contract is actually created or not. Yeah, so, and what could be problematic, for instance, in a common law sense, is whether there's actually a manifest intention to create a contract at all. So you end up with this kind of complex array of different frameworks and trying to fill in what could be fair in particular contexts, and you're trying to mash things together. Yeah, so I think like the point that I want to end on maybe with this is that there is a serious amount of complication in aligning different notions of fairness that start in different frameworks, because the policy-making intention behind those it was potentially different from the outset. Yeah, be that, I suppose, more internal market orientated, and even, I suppose, within the GDPR, if there's an internal market role, there's still a stronger, I suppose, charter, the requirement to respect fundamental rights and freedoms more generally. So I think in the interest of time, I'll stop there. I realize that there was quite a lot, but I'm happy to kind of further elaborate on things in questions.
Yes, thank you so much, Damian. Thank you for sharing these cases. I think they're indeed a very good input to the discussion we're having here, and to see whether fairness could indeed have this, or could be expected to bridge this gap, have this role that would be an instrument towards legal interoperability. And thank you for those takeaways, maybe following up on the first, saying that it's really stressing the complexity. I would really like to invite our audience, if they are confronted with questions, they're still burning, please put them in the chat of the B2 match, and we can come back to them in the roundtable. And then also following up on your second takeaway, Damian, of it being context dependent, I think that's what we realized as well when we were setting up this workshop. And so I would like to proceed to the second speaker. And this context-dependent element, this contextual nature of the interpretation of fairness, this is why we want to delve more into details into the health data space. And so we've invited Theodora Lalova, being a doctoral researcher at the KU Leuven's Faculty of Pharmaceutical Science and at the Center for IT and IP Law. whose research focuses on the fair allocation of data control and responsibility in precision medicine. So I would like to really give the floor to Theodora to go into more details also on the use case here of the health data space. Theodora.
Thank you very much, Natalie. Thank you very much, Charlotte and Natalie. It's a pleasure for me to be part of the workshop today. I will share my slides. So for the purpose of our discussion today, I decided to focus on the notion of data control in the European Health Data Space proposal, looking through it to understand better how the notion of fairness is operationalized. A little note is that unlike the Data Markets Act, the Data Act, and the Data Governance Act that Charlotte discussed in the beginning of the workshop, fairness is not really discussed within the Health Data Space proposal. So I'm focusing on specific provisions to highlight the complexities, to really show concrete examples of discrepancies between what is to come, what is existing, what is positive, and what could be seen as quite challenging for the future. And I'm also going to a little bit map the Health Data Space proposal itself, just to give a background of what is new and how this is going to apply in relation to all of the other frameworks. So that's why I've titled my presentation Highlights. It's impossible to go over everything, but really to focus on some concrete examples. I will start by presenting what is actually the health data space, look into the scope, and then look into the promise for strengthened individual control over health data. And this is quite important. It's a topic we have also looked together with Charlotte and another colleague from CTIP, Lydia Duchkiewicz. The fact that similar to fairness, the notion of data control, it's not really defined. It's quite a vague notion. It's very much prominent in policy and in legislation, but we're lacking a concrete definition and how to understand it. I'll finish also with a little bit of a note on the governance, on the plethora of new bodies that are being established with the health data space, and how this could be also seen from the point of view of fairness, and some key takeaways. So what is in a name? The European Health Data Space, that's the first proposal actually for a domain-specific common European space. We're to expect, as promised in the European Data Strategy, several more to come. So this is also interesting use case in terms of what we are to expect in the future. This is kind of the first blueprint, first example. In terms of the objectives, what I noted as very interesting is that the main objective that is stated both in the recitals and in the explanatory memorandum and in every material discussing and promoting the health data space, that is the increased control for natural persons over their electronic health data. So really the focus is on the individual, on the data subject. And only secondary, it seems to be, looking at the text, come two more objectives, namely a legal framework consisting of trusted governance mechanisms and a secure processing environment, and also that the new regulation should contribute to a genuine single market for digital health products and services. I would like to discuss very briefly what electronic health data means, because it's crucial when we think of this further empowerment of the data subject, what we're seeing now with the health data space. And in particular, electronic health data is not limited only to personal data. It's not limited only to the data protection legal framework. It also encapsulates non-personal data. Another important takeaway is that personal electronic health data is not simply data concerning health and genetic data as defined in the Gdpr, but there is also reference to data referring to determinants of health, example being behavior or physical characteristics of a person, or data processed in relation to the provision of healthcare services. This is interesting for future discussion, but as a little note, to me, this is kind of broadening the definition of special categories of data under the GDPR. Very interesting, very important to keep in mind, in my view. Also very important is that the European health data space is promoted and is supposed to be seen as building upon already a plethora of previously existing acts. at the crux of it, that's the data protection, the General Data Protection Regulation, but also the newly proposed Data Governance Act, the Data Act, the AI Act, and in the field of biomedical research, the In Vitro Diagnostic Medical Devices Regulation, the Medical Devices Regulation, and the Cross-Border Healthcare Directive. It's quite a complex system, and this is just what is mentioned in the proposal itself. But we should keep in mind, because my research is concerned on biomedical research, that we have even more acts that are not specifically mentioned, but still the data space is going to be applying in conjunction with them, and it's going to be in an interplay with them. Just as an example, the Clinical Trials Regulation, biobanking rules that are not harmonized at all across the European Union. And we should also keep in mind ethics, Helsinki Declaration, Oviedo Declaration. The fact that clinical research is also under the scrutiny of ethics committees that look from their point of view into the fair balance of, on the one side, the physical integrity and the protection of fundamental rights of patients participating in studies. All of this, it is there, it is applicable, and the data space and the rules established with it is going to be also applying with that. So what is the scope of the health data space? Again, very much prominent within the regulation, within all the articles, within the recitals, is the fact that it's there to strengthen the rights of natural persons in relation to the availability and control of their electronic health data. So we're seeing a broadening, and later on I'm going to show some examples of data subjects' rights under GDPR, broadened and enhanced, both towards personal data, but also non-personal data, which is also quite interesting. Also, it is there to establish rules for placing on the markets, making available and putting into service of electronic health records systems. Very important when we discuss control and fairness rules supporting secondary use of electronic health data, and the establishment of 2 mandatory cross-border infrastructures that enable, on the one side, primary use of electronic health data, and on the other side, secondary use of health data, for especially for scientific research. To whom it applies, the regulation, manufacturers and suppliers of electronic health record systems and wellness applications, users of such products, controllers and processors established in the Union that process electronic health data, controllers and processors established in third countries that are connected with one of the exchange platforms that the health data space is bringing, MyHealth@EU, more to come in a minute, and data users to whom electronic health data are made available by data holders in the EU. 2 important definitions that I would briefly like to highlight, and that also show the difficult interplay with other legislations. That's data users and data holders under the European health data space. So the definitions themselves: data users, a natural or legal person who has lawful access to personal or non-personal electronic health data for secondary use. Data holders, any natural or legal person who has the right or obligation to make available certain data. So just a brief note, what I found quite interesting, we have the same terms, data users, data holders, also in the Data Governance Acts and also in the Data Acts. And here I would like to refer to previous research with colleagues from CITIP, the CITIP white paper on the Data Governance Acts, because there we have been quite critical on the notions, the way, the terminological ambiguities and difficulties. I'm not going to go into the details, but the same issues that we highlight there are going to be applicable when we think about the health data space. And moreover, there are slight differences between the definitions in the data space and in the Data Governance Act. So we have 2 acts that are going to be applied together. One is the horizontal framework, the Data Governance Act. Then we have the data space specific framework with differences, with unresolved problems coming together. Also crucial for the health data space, we have definitions of primary use and secondary use. Primary use, that is really the processing of personal electronic health data for the provision of health services. There is a lot to be lauded there, because really the health data space opens up the possibility for receiving cross-border healthcare in a much more feasible way for individuals within the EU. But then we also have a lot of ambiguities on the other side when it comes to secondary use, defined as the processing of electronic health data, both personal and non-personal, for specific purposes that are set out in Chapter 4 of the regulation. Examples that I include, that would be activities for reasons of public interest in the area of public health. Think about pandemics, scientific research, or even training of algorithms. And again, just a brief note of some of the uncertainties that I'm seeing at this stage. Under the data protection framework, we speak about further processing of personal data. We have never had a definition of secondary use, although it is a term that is being discussed, especially in biomedical research. Now we get the first definition of what secondary use is, but still we have not a discussion of compatibility, of how the rules would apply together with the data protection framework. The European Health Data Space as well creates obligation for data holders to make available data to secondary use. Not going into the details of that, but to keep in mind, quite interesting. So focusing now on the promise for strengthened individual control over health data. Specifically in Chapter 2 of the Health Data Space, there are enumerated several tools that could be seen as really substantiating data control for natural persons, for data subjects. Most of them are actually building up on data subject rights under the Gdpr. That would be an enhanced right to access, an enhanced right to rectification, enhanced data portability rights, right to insert electronic health data in your own European electronic health records or into the health record of natural persons whose health information you can access, for instance, your kids, a right to restrict access of health professionals to all or part of your electronic health data, which is subject to limitations, a right to obtain information on the healthcare providers and health professionals that have accessed your electronic health data in the context of healthcare specifically. And also there is the establishment of a common European electronic health record exchange formats, which is going to bring more interoperability, specifically with travel and crossing the borders for healthcare. I would like to focus on one of these enhanced rights, specifically data portability, for several reasons. First of all, it has been promoted both in policy and also in all of the new proposals like the Data Governance Act and the Data Act as the main data subject rights that substantiates data control, being in control of your own personal data. It's also very much linked to one of the other crucial new mechanisms also promoted as in terms of fairness and more data control, namely data altruism that was established with the Data Governance Act. It is via the data portability rights, namely the right to obtain personal data related to you, concerning you, and transmit it to another controller, that the data altruism mechanism should be operationalized. And I'm going to briefly guide you through what is data altruism, why data portability is crucial, what are the problems there, and how we have several uncertainties placed within the European Health Data Space on the one side. And also I'm going to mention the Data Act, because data portability is receiving now two new, let's say, clothes, two new versions on top of what we already exists and we have under the GDPR. What is data altruism under the Data Governance Act? So both natural persons, data subjects, and legal persons, let's say companies, have the possibility to make available, to share their either personal data they hold or non-personal data via consent or permission for the legal persons to data altruism organizations, a new actor, a new player in the data value chain, who in turn would be able to share this data with various stakeholders, data users, for purposes of general interest, to use this data, to reuse this data, secondary use, for the common goods, including a big example that here would be scientific research. However, data altruism, to make it workable, the data itself, the personal or non-personal data, should be in the holds of the data subjects or the companies that would like to share it. I'm not going to go through all the possible problematics of data altruism. Again, I'm going to refer to our CTIP white paper on the Data Governance Act. But while on the one side, data altruism seems promising for motivating people to share data or for specifically fostering health research and innovation, there are numerous issues that still need to be resolved and discussed. On the one side, terminological ambiguities, there is the notion of consent, whether it should be the same as the GDPR, but a lot of problems there. General interest, is it the same as the notion of public interest under the GDPR? Not so clear. Lack of clarity as regards the interplay with other key legislative acts, notably the GDPR, but also when we think of clinical research, clinical trials framework, potential risks to the fundamental rights in terms of patients specifically. There is quite a bit of a lack of stakeholder involvement when it comes to data altruism under the Data Governance Act. Challenges related to the roles and responsibilities of these new service providers, the data altruism organizations. And we come now to the data portability rights, which is supposed to be key and is promoted as key for instrumentalizing the mechanism. However, under the GDPR, it comes with several key limitations, which would limit the context in which you'd be able to port your data for data altruism. Notably, the personal data must be provided by the data subjects. It's not possible to port inferred data, which in the context of health, this means that, let's say, diagnosis or tests, lab tests, that's not part of the scope of the data portability right. Also, the data must have been initially processed based on only two legal bases, either consent or contract. And processing should be carried by automated means, that's okay. But in health research, other legal bases than consent have been reported as more preferred and even encouraged by the EDPB in the scope of clinical trials. That would be legal obligation, public interest, or legitimate interest. So in the specific context of, let's say, a clinical research study, whereby an individual would like to indeed share their data for altruistic purposes, the data portability rights is too limited. And if the research is being conducted on the basis of public interest, they would not be able to do it. However, the European Health Data Space broadens data portability as we know it under the GDPR on several grounds. First of all, but there are some questions here, it seems to be opened both to personal and non-personal data, electronic health data. The fact whether it's really open to the non-personal, this is not so clear, because whereas the articles speak of electronic health data points, and the definition of electronic health data includes both personal and non-personal data, in the recitals, the discussion is only about personal data. So there is still a little bit of ambiguity between the text itself. The data portability rights under the health data space also includes inferred data, diagnosis, lab tests this would be possible to port and to share. As well, it's applicable irrespective of the legal basis for the original processing of the data. So we don't face any more the limitation, consent or contract. It could have been any other legal basis. But if we think about data altruism and really making it practicable for individual in all settings, the health data space is not so clear whether that's really the case, because it seems that the new data portability is really limited to the care setting, to the provision and receiving care services. This is because it's part of the health, it really refers to the health or social security sector, and it's part of the chapter specifically applicable to primary use. So we're not so sure, is it part of data altruism or not? A very brief note on the Data Act, because I think it's interesting to compare the fact that we have one more iteration of data portability, different than what we have under the GDPR. There, for sure, first of all, the context is only IoT, Internet of Things, products and services. It's limited to that context. But there it encapsulates both personal and non-personal data, for sure. It is about actively provided and passively observed data. It is irrespective of the legal basis. And we have a very key difference, that it is open to legal persons as well, because the definition of user who could rely on data portability rights under the Data Act encapsulates both natural and legal persons. Some questions for future discussions on these parts. So the broadening of the data portability right raises questions with respect specifically to individual empowerment and data control. First of all, it's not so clear how the Health Data Space and the Data Act proposals should be applied in conjunction with the GDPR itself. It is also unclear whether the data portability under the Health Data Space proposal truly operationalizes data altruism, or it's really intended only for the purposes of cross-border healthcare, receiving healthcare abroad. And this opening that we see all of a sudden in the Data Act to legal persons to be able to rely on data portability, a data subject's right, how this reconcile with the objective that is quite promoted across the new frameworks of individual empowerment, and what would be the appropriate safeguards against potential misuse? This is not so clear. If I have some time, let me know if I'm overstepping the time. I will discuss a little bit the governance as well. So the Health Data Space proposal establishes new bodies, both for primary and secondary use. My slides, okay, started working again, sorry for this. So it establishes a new board, the European Health Data Space Board, that I'm going to briefly describe in a second. It also refers to data protection authorities when it comes to the monitoring of processing of personal electronic health data. It creates platforms for exchange of data, both for primary use, the My Health at EU, and for secondary use, Health Data at EU. It creates digital authorities, digital health authorities that would be really supervising the establishments, the application of the rules for primary use, as well as national contact points to allow the exchange of data via My Health at EU. And similarly, health data access bodies for secondary use that would be issuing permits, data permits, to anyone requesting the access and the use of secondary use from data holders that are obliged to be able to provide data. When it comes to the European Health Data Spaceports, the aim is to facilitate cooperation and exchange of information among member states. The composition, that's representatives of digital health authorities and health data access bodies of all the member states. Here, very important in my view, is the emphasis on stakeholders' involvement, particularly patient representatives, in its meetings and participating in its work, which is something that was missing, this part of stakeholder involvement in the discussion on Data Governance Act, the competent authorities there, or the data altruism organizations. And the Health Data Space Board should cooperate with other relevant bodies, entities, and experts, inter alia, quite a long list, the European Data Innovation Board that is created with the Data Governance Act, the competent bodies set up under the Data Act, supervisory bodies set up under the EID regulation, the European Data Protection Board. So it's a very complex framework, all coming together, all having to coordinate together. Some quick key messages. So the European Health Data Space proposal promises to strengthen individual control over both personal and non-personal electronic health data. However, questions remain, especially as regards the individual control in the case of secondary use of electronic health data. I gave the example of specifically data altruism, but we should keep in mind that there is an obligation to data holders, specifically think of, let's say, companies or research institutions, to share data. And there is not enough discussion. There is really a step away from consent from the individuals when it comes to their own personal data being shared further on. What would be the checks and balances there? It is also not clear how key new rules, for instance, specifically the broadened data portability rights, would align with the frameworks that are already established in other legislative acts, GDPR or the Data Act. And the Health Data Space proposal establishes yet another set of competent bodies, a plethora of competent bodies that should cooperate with what we already have. So the big question for me that is still to be realized and to be further discussed is how the data space proposal will fit within the existing very complex legal framework for biomedical research. Big question mark also for further discussion would be specifically when you think of ethics committees' role in biomedical research as well, and the checks and balances that they do. With this, I thank you very much and happy to take any questions.
Thank you very much, Theodora. Really good how you gave this context on individual data control, data altruism, data portability as manifestations of fairness. And I would like to give the floor for a question to Charlotte, connecting it back to indeed our previous discussions on fairness.
Thank you, Nathalie. Thank you, Theodora. It's super interesting and quite complex for someone not versed into health law. But yeah, it's interesting also because it's, as far as I know, the first data space regulation proposal, although we have a few legislative proposals on media, I think, and now on open data, high value data sets. But I think this one on health data space is really a big chunk. So it's super interesting to see how indeed the European Commission is trying to substantiate those big notions of like fairness and so on. And linking back to what you said, especially on data control, my question is the following. So in my understanding, data control is viewed by the Commission as a means to create a fair data economy. So it's coming up over and over again. In my understanding, what the European Commission means with a fair data economy is a data economy with the European values. And deeply rooted to this seems to be the idea that there should be fair data markets, where both individuals and companies would be active and happy participants and so on. Do you see the health data space regulation proposal as a means to substantiate those principles? And do you think it works? Might be a bit long, but.
Thanks a lot for this question. It's very interesting. And to be fair, for myself, I'm still making my mind, because especially what you said about having happy participants in the data economy, being willing to share data. So on the part of primary use of data, which is really for the care setting, I have a lot of positive feelings, so to speak, towards the proposal, because indeed, if you look at the enhanced tools for control, the enhanced data rights, patients, especially in the setting of a cross-border healthcare, they would have more opportunities to benefit from more opportunities to receive healthcare, to benefit. There is a lot to speak about that. But when it comes to control in the setting of secondary use of data, to me, I have still a lot of questions, and still I'm very curious how the proposal itself might change and what would be the feedback from stakeholders, because what I'm seeing from the point of view of the researchers or the companies, it makes things easier, indeed. It makes it more feasible, it gives more access to data. But from the point of view of the individual, to me, there is a big unclarity or a gap, because, for instance, all of these enhanced tools that we're seeing for control, to me, it's not clear whether they apply in the context of secondary use of data. It doesn't seem so at the first glance, at the first reading. It seems to be really limited to the care setting. Second of all, there is also the example of, we know that for control, also in terms of empirical research, that have empirical scholarship, a key part of control is transparency, being informed of what is happening with your data once it has been shared for research. For patients, it has also been reported how important it is that they know that the data is used for a project, that they see the impact of being participants in the research. But I'm going to cite a particular provision of the health data space. I cannot now cite the concrete number, but the health data access bodies, the ones that are going to be, so to speak, the gatekeepers and issuing the permits to receive access to data, there is a specific reference that they benefit from the exceptions of the transparency obligation under the Gdpr, Article 14. So they should provide publicly available information about projects and how the data is used, but it's not specified where, we suppose on their websites. It's not specified how patients, for instance, would be able to really get to know what is happening with their data. And there is already this really substantiated barrier. The information is not going to be fed back to them. And in scholarship, there is a lot of discussion about and a lot of voices for, let's say, using electronic health records for providing information about research, how the data is being used further on. To me, it's a little bit of a missed opportunity that has been not specified in the proposal, really operationalizing in a very practical way towards the patient. So that's one big part of it for me. The transparency towards the patient is missing. Another interesting example, so to speak, would be the fact that health data access bodies that are themselves to be seen as a sort of service providers. It is mentioned that they should cooperate with the competent authorities under the Data Governance Act to monitor data altruism organizations, which are also providing, sharing data. So we have, to me, it's a bit strange. It's something to be further looked into, that one service provider supervises another service provider. How this is working in terms of fairness towards the individuals, I'm not sure at this moment. I still myself have to better understand the complexity of the health data space proposal. But there is, to me, a lot of discussion specifically on secondary use that I'm not sure how exactly. One positive side would be the emphasis on stakeholders' involvement, that patient representatives should be more involved in the different bodies, in the different governance models. But again, not clear to me beyond that how exactly trust is created for the patient. There is also the step away from consent. Consent is not at all the crux of the proposal for secondary use. Going away from previous approaches, previous discussions, consent seen as the most empowering tool. So a lot of questions to myself. At this moment, I think it's not really possible to say whether it's making individuals happy, but it's fascinating. Thanks a lot for the question.
Thank you very much for the elaborate answer.
Yes, and thank you, Theodora, for connecting also back to the governance issues, to the roles of those dedicated administrative authorities, and looking at the relationships between the various authorities. And on this note, I would like to introduce the next speaker, Dr. Inge Graaf. Inge is Associate Professor of Competition Law at Tilburg University and affiliated to the Tilburg Institute of Law, Technology and Society and the Tilburg Law and Economics Center. And Inge, I would really like to also mention your activities as co-chair of the Digital Clearinghouse Initiative, which aims to facilitate the exchange of insights between regulators across Europe and beyond in the areas of competition, data protection and consumer law. So Inge, please, you have the floor. Thank you.
Thanks a lot, Natalie, for the kind introduction, and thank you for having me here. So I prepared an intervention on what I've called the multidimensional nature of fairness. And this refers to the fact that fairness brings interests of different parties together that cannot always be optimized. So there is trade-offs that need to be made in the different parties that are, for instance, involved in an exchange of data, which is one form of the multidimensional nature. But of course, fairness has also different interpretations depending on what legal regime you look at it. And I will discuss a few examples in this sense, but I would also like to look at this multidimensional nature of fairness in the particular context of data intermediaries. And data intermediaries are a new actor, or an actor that at least the EU legislator now wishes to promote, especially if you look at the Data Governance Act. And considering that fairness is an important value in the exchange of data, it also seems that these data intermediaries really have a key role in doing this trade-off between different interests, between different forms of fairness. And I think it's interesting to have a look at how this could work in practice, and also how these trade-offs can be monitored by regulatory authorities who come from different backgrounds. So let me start off by looking at the provisions of the Data Governance Act, because the Data Governance Act really seems to, as one of its objectives, seems to want to promote the development of these data intermediaries, or data sharing services, as they are called in the legislative text. And if you look at the Data Governance Act in Articles 9 to 14, based on the European Commission proposal, there is 3 types of data sharing services that are defined there. So one type is the more business type of data sharing services, where we speak of intermediation services between data holders with legal personality and potential data users. The second form is more targeted at intermediation services that help data subjects exercise their rights that they have under the GDPR. So this is more a B2C type of scenario. And then there is also a third type of data sharing service, which is the data cooperatives, where individuals can pool data, and there is a form of collective governance to then govern the data cooperative. And in order to stimulate the development of these data sharing services, the Data Governance Act has come up with a light form of procedure to create more clarity about how these data sharing services or data intermediaries should function. And there is a data notification procedure that is laid down. So this means that if you are a data sharing service, if you want to operate in the EU, you have to notify yourself to the competent national authorities, and only in an ex post manner, these national authorities are then responsible for monitoring whether the data intermediaries comply with the applicable rules. So this is a bit of a light touch regime in the sense that the only thing you need to do is to notify. There is no ex ante certification or ex ante check. You just have to notify and give us some points of information to the national authority. And I think this is very interesting choice, because if you look at it, these data intermediaries do have a very important role, I think, in the whole data landscape, because they are responsible to a certain extent for preserving some public interest that we really deem as being very important, which includes things like data protection and competition. So I put on the slide here part of Article 11, and this Article 11 lists the key requirements that these data intermediaries have to comply with under the Data Governance Act. And if you go through the list, you will see that actually a lot of different things are mentioned there. So providers of data intermediaries have to ensure fair, transparent, non-discriminatory access to their services. Also, when it comes to prices, they need to prevent fraudulent, abusive practices in relation to access to data from parties seeking access through their services. There is provisions on access and transfer of non-personal data, the security provisions, and then indeed you also see that they have a role in ensuring compliance with the competition rules, and also they have to act in the best interest of data subjects when they facilitate their exercise of rights of individuals under the GDPR. So this is actually a very long list which refers to many different public interests, many different legal regimes, where these data intermediaries really have a key role in being the first monitor for ensuring that the data exchanges that go through their platform comply with all of these different provisions and different interests. At the top here, you also see that one of the obligations on data intermediaries is that they have to be neutral as regards the data that they exchange. So this means that they cannot be vertically integrated. There should be a structural separation between the services that they offer as an intermediary. So making sure data can be exchanged between parties, either between businesses or between a business and a data subject. But they can't use the data that they exchange to offer their own services. So this seems to be a strong requirement of neutrality that acts as a safeguard against certain forms of concerns that we would otherwise have. So this is just a graphic trying to display the different relations that we would see here for these data intermediaries. So this would be the example of a data intermediary that helps data subjects exercise their rights under the GDPR, where the data intermediary really acts a bit as a platform between the data subject on the one hand and between the data user on the other hand. And there is various relations that come into play here. So of course, the intermediary has to act, as we have seen in Article 11, in the best interest of the data subject. So there is a form of fairness that plays a role there. But the intermediary also has relationship with the data users where also fairness will play a role. So this already shows that there is different forms of fairness, different interests at play, and also interests need to be balanced. Of course, also these data users have a relationship with data subjects. So there is also a form of fairness there. The question that one could ask is, to what extent are these data intermediaries then responsible for the relationship that a data user in the end has with a data subject? So to what extent can their responsibility be stretched? So what is the extent and reach of the fairness that they have to operate on their platform? And I think this idea of giving intermediaries a lot of responsibility in this data value chain is quite remarkable, because if you think of other legislations that are now either already adopted or in the process of being adopted, there seems to be a lot of concern about private players playing a strong role in balancing public interests. So this probably is clearest in legislations regarding the Digital Services Act and the Digital Markets Act, which both target the power that digital platforms have. So either in the Digital Markets Act, the power of controlling markets, steering innovation, or in the sense of the Digital Services Act, content moderation platforms that can influence how freedom of speech or freedom of expression is being exercised. And these two legislations, what they do is impose additional restrictions on those platforms that so far have quite a lot of discretion in balancing these different interests and making choices through their terms and conditions, for instance, on how certain public interests should be enforced on their platforms. So all of these concerns relate basically to platforms acting as what is called private regulators of public interest. And these laws really try to limit the discretion of the platforms in being sort of a first line enforcer of public interest that we deem as very important. So for that reason, I think it's interesting to see that the Data Governance Act seems to give data intermediaries a similar type of regulatory role, because they are in a way also the first line enforcers of all the obligations that we have seen in Article 11. So there is this notification framework with an ex post monitoring by national authorities, which means that in first instance, the data intermediaries themselves have to make sure their platforms are set up in a way that make sure that there is compliance with all these different interests and regimes mentioned in Article 11. So this is quite interesting to see that on the one hand, in the big tech area, we are very concerned about private players taking up roles as enforcers of public interest, whereas in another area, which is obviously less concentrated and where the concerns may be not as pronounced, but still we are going to give a new type of entity that we want to stimulate a similar type of regulatory role. And I think this really calls for more proactive guidance to make sure upfront that there is more clarity about how those new actors, how those data intermediaries can exercise their responsibility. Here, there might probably be less, there is less risk that they will act in a very strategic way, since there is much more, the market is still much more open. But it might also be that if there is a lot of uncertainty about how those specific obligations have to be applied in practice, that we don't see a lot of the potential of these data intermediaries to actually occur just because of legal uncertainty. So despite the fact that there is this requirement of neutrality, which I think guards against part of the concerns that we have in the Digital Services Act and Digital Markets Act, I think it's still important to create more clarity upfront about how exactly data intermediaries should exercise their responsibility, and what is also the reach of their responsibility that they have, because they will be key actors in making those trade-offs between a long list of public interests. So then moving beyond data intermediaries, I wanted to give two examples of situations where I think you clearly see that fairness cannot always be optimized in different perspectives. So there is a trade-off between different interests of the parties, but there is also trade-offs that need to be made between different legal regimes. And one example comes from the Digital Markets Act. And as you know, the Digital Markets Act focuses on so-called gatekeeping platforms that have a strong position in digital markets, where from an ex-ante perspective, these gatekeepers have to comply with a number of obligations that are listed in Article 6 and 5 of the DMA. And you see here on the slide, Article 5 sub A of the DMA, which is an obligation that applies to gatekeepers in the context of personal data combination. So what this provision says is that gatekeepers should refrain from combining personal data across their services unless the user has provided consent in the sense of the GDPR. So when we think of gatekeepers, they indeed often are players that have a whole portfolio of services, where the data that they collect by offering one service can sometimes also be of value for offering another service. So in practice, a lot of this exchange of personal data across services is happening, even though you could already, I think, challenge this based on the GDPR, for instance, relying on the purpose limitation principle. So what the DMA says is that we are indeed also from the perspective of fairness and market contestability, those are the objectives of the Digital Markets Act, we're concerned about this form of data combination across services offered by gatekeepers. So for that reason, they can only combine personal data across services when the user has provided consent. However, my view is that this is still quite a weak provision, a weak obligation, because if our concern is really about fairness and market contestability, which is more like a macro objective, we leave the extent of fairness and market contestability basically in the hands of individuals, because if many individuals still give their consent to combine personal data just because they are nudged to do so by a gatekeeper, or they don't see any concerns in the longer term and they just see short-term benefits because they will have more relevant services, then this means that also the market overall will not become more fair or not become more contestable, simply because the majority of individuals, the majority of users still gives consent. So here I see a clear tension between the interests of the individual to control how their own personal data is being combined, and the more macro objective of how an individual choice can affect interests of other data subjects, and also the collective interest in having fair and contestable markets. And this, I think, is a key policy challenge where it seems so far that there is no that is still seen as very controversial to limit the control of individuals just for the purpose of achieving a more longer term and more collective objective of having more competitive, more innovative markets with, in the end, I think also more choice for individuals. So I feel like this is a tension that comes up in many different areas, and this provision in the DMA is one example where you still see, despite the fact that fairness and market contestability is important, we still leave a lot of responsibility with the individuals, which I think risks the fact that in the end, the DMA will not reach its full potential and will not make markets much more fair or contestable, especially when it comes to personal data combination. Then the second example that I wanted to discuss is an example where competition and privacy or data protection are sometimes not fully aligned. So there have been a number of cases in the past years that clearly show this. And these cases, again, go back to big tech firms. And what you see here is an example of an advertising platform, Google, that updated its browser settings with its privacy sandbox, where it started to remove third-party cookies based on privacy concerns. So the argument of Google is we really want to improve the protection of privacy of users on our platform. So for that reason, we are not going to allow third-party cookies anymore, so that third parties cannot track users across or different or ecosystem anymore, which is good for privacy. But on the other hand, it's also a very convenient strategy for Google, because in the end, by not allowing third parties to track users across Google services anymore, it also can increase its own position in the advertising market, because of course Google itself will still be able to track users across services. So this is an example of a scenario where prominent firms can rely on privacy as a sort of excuse to keep their platforms closed, which in the end might limit competition and might limit innovation, might limit consumer choice. So the question then is, how do you achieve a result that is proportional, that is good for competition, but also good for privacy and data protection? And in the UK, so this is the investigation of the Competition and Markets Authority. In the meantime, they have managed to get commitment from Google on this, where I think it's interesting to see how the CMA really tried to collaborate also with the privacy regulator to find a solution that really balances the need for competition, but also the need for privacy. And this then brings me to my final slide. Yeah. Because indeed, as Natalie was explaining in the beginning, one of the projects that I've been involved in the past years deals very much with this collaboration between regulatory authorities. And I see this really as something that really deserves a lot of attention. I think all the proposals that we now see coming up from the EU all really point at this. So we have new rules that are welcome, but enforcement is also really important. And many of these legislations bring different concerns together, where I think different expertise of different regulators need to be used. So a question is how you can make that type of collaboration work in practice. And here I think you could think of different models of cooperation and also different levels of cooperation. So at the very least thing I think that should happen is that there should be room for authorities to mutually consult each other on cases or on issues of common concern. So some countries in the EU already have memoranda of understanding between different regulators, which gives a bit of a formal basis for them to exchange information. So this could be very in a more informal way, but this could also be in a regulated in a stricter way, in the sense that there could be a duty to consult before one authority can adopt a decision that also has an effect on an area of law that is for which the responsibility lies with another authority. But not all member states in the EU already have such memoranda of understanding or already have such protocols in place. And I think it's important to create this. Also, if you look at the Data Governance Act, it also has a provision that indeed says different competent authorities have to be able to exchange information with each other. So I think it's important to really improve this type of information sharing, which could take different forms. So it could be about pooling knowledge, just even not tied to a particular case, just having having workshops, meetings, or having exchanges of insights between regulators on a particular topic. But it could also be stronger in the sense that, for instance, maybe a competition authority starts to investigate a case, but at some point it finds out that actually the key concern in the case is more towards a data protection concern. So then there could be a mechanism to easily reallocate cases from one authority to the other, which also allows authority to then bring their evidence to a next investigation, because confidentiality plays a role there. And without these memoranda of understanding, it seems very difficult to actually do this in practice. Could also take the form of facilitating synergies where, for instance, the interpretation of a concept in data protection could be further developed when you have expertise from a competition authority. So, for instance, what is really given consent, which was something that Damian also referred to. If you deal with a dominant company, maybe you require some knowledge from a competition authority that could help you understand when consent can still be freely given when you're dealing with a dominant firm. Then another type of corporation could be further. So it could also be about joint case handling, so where you can have joint investigations or maybe even joint design of remedies. So authorities could divide tasks. So for instance, when a competition authority imposes a duty to share data for the purposes of keeping markets open, this, of course, also needs to be implemented in a way that complies with data protection law. So a data protection authority could then be involved in the design of the remedy, or maybe could even be put in charge of monitoring how this remedy is being implemented. Then another form of cooperation could be joint policy making. So a good example of this again comes from the UK, where in May last year, the CMA and the ICO published a joint statement on competition and data protection law, which I think is a very good example of authorities coming together, pooling knowledge, and also creating some clarity to the market upfront on how they will deal with cases where the two areas of law really intersect. So I think these types of cooperation, whatever form they take, they will also be very important in implementing some of the legislations that we are discussing here today, like the Data Governance Act and the Data Act. So I will stop here and look forward to the discussion.
Thank you very much, Inge. Very valuable input. And we see that the questions are already coming in on the Bit2Match chat. I would really also like to the other members in the audience repeat that you could still enter those questions. And I would now like to hand the floor to Charlotte again for the second part of the roundtable.
Thank you, Nathalie, and thank you to all the speakers. It was extremely informative. So the last part of our session takes the form of a roundtable with all the speakers. In this roundtable, we will try to stimulate discussion between the speakers and with the speakers and the audience, but we also welcome two additional speakers, our surprise guests. So we have industry in the room. So based on everything that has been said so far, Nathalie and I really wanted to have the view of industry on how they picture their role in this. We see the legal frameworks are a bit complex. This notion of fairness is expected to play a number of roles, and especially, and this is what we wanted to discuss today, it is especially designed to play the role of legal interoperability tools. So this idea that with data and in the digital environment, we have many legal frameworks that come together, and for that sake, many administrative authorities. This was discussed by all the speakers in a way or another. And now, how do we put it in place? How do industry and private entities see their role in this? So the way it is going to take place is the following. So first, I will give the floor to Bert and Annika So they give their impression on this, and then we will have a discussion with actually all of us. We already have a question in the chat. It's not forgotten. It will be perfect in the round table, but if I may, we will start with Bert Spreubers. I hope the pronunciation is correct, from Agoria. So Agoria is a gathering of Belgian industry in the digital environment, if I may, or technological environment, more generally.
Exactly.
Yeah. So Bert, the floor is yours, and we are very looking forward to your thoughts on all this.
Yes, thank you. So as discussed, my name is Bert Spreubers. I work with Agoria, so we're basically the technology federation in Belgium. And I myself, I'm a company lawyer. So I work with companies on a day-to-day basis. And basically I write contracts for them and give them legal advice. And yeah, so when I look at this term fairness, I see it as quite an important underlying principle of legislation. And so in first instance for legislators. What I wonder is, how suitable is this term as a legal provision, as something that should apply to companies? And then I might link it to my day-to-day job. Because when I write contracts for businesses, I always have this objective, and that I need to keep these texts as short and simple as possible. So what I need to do is avoid clauses and terminology that are not really useful, especially if certain terms can lead to discussions, if they're vague, and basically if everyone has a different interpretation of these terms. So my question is, what impact does this term fairness have for this existing legislation, right? And for the new legislative proposals we've discussed. So what I think is, on the one hand, if we take this term fair or fairness out of these proposals, what would happen? And if we keep this term in there, what would the impact be? And I think the answer to the first question might also be the answer to the second one, but I'll leave that for you. That's my question. Thank you.
Thank you very much, Bert. Do you also have views or questions, for that sake, on the role of competent authorities? We have many legacy ones, so to speak, and new ones. What do you expect from them?
Well, I think we need some guidance to implement this, because I mean, I was quite glad that some of you mentioned that this regulatory role is shifting a bit from legislators to, in first instance, a number of gatekeepers, but also to basically any entity in the market. And therefore, I would suggest that if you impose a vague notion such as fairness, that you'd at least explain to these entities how to implement it, whether this is fairness for society, whether this is fairness between contract parties, because that's basically it, right? It's about fair licensing terms. Whether you need a certain assessment, I think that would be helpful, and that would be, especially in the beginning, a big role for these regulatory authorities.
Thank you very much, Bert. So fairness as a hot potato, if I may. Then it's my pleasure to give the floor to Annika Link. Annika is here on behalf of Digital SME. So Digital SME is an alliance of SMEs at EU level that are active in the digital environment. I think that the name is actually very telling. So we had the view of Belgium industry. Now we have the view of SMEs at EU level, and I think it's important to have SMEs, because we know that in this package of legislative proposals, the European Commission was all about SMEs. They really want to help SMEs, and this whole idea about having a fair economy, a fair data economy, is targeted at SMEs. So I'm very curious to know how you feel about this and whether you feel that it delivers.
Yes, thank you so much. And indeed, well, it's as the speakers have been painting a very complex picture. It's not so obvious for the companies to make something out of it. And I would agree with the previous with the remarks on that it actually has to be specified in a way that it can be implemented and that it's clear for the companies what does that actually mean in the daily business practice. But I also wanted to take a little bit of a step back, just to take the perspective that we've been taking as a business association. So, I mean, I guess it's a little bit subconscious that also we, in our terminology, we often speak about the fact that we need fair, competitive markets. So it comes more, you know, from the sort of competition or economic perspective that we often realize that smaller players are, on the one hand, they're disproportionately more strongly affected by administrative burden. So, of course, if you have new rules and legislation, the sort of proportionally, a smaller company has less people to be able to implement that. They don't have, you know, a team of in-house lawyers. They have maybe one person dealing with it, whereas a large company has 20. But then this also is also a sort of imbalance in resources, financial resources, HR resources, etc. So we ourselves, as a business association, we often talk about this sort of imbalances and that we need more fairness in the market. And I find it quite interesting because, yeah, in a way, I guess there's this, you know, there's this conversation happening where people realize that, especially in digital environments, some of these balances have shifted. And I think this is also something what was the intention with the GDPR, at least from, if I'm not wrong, you know, in the end, as Damian was explaining, also the fairness is there. And it came also from the fact that you have the large, or you have like the means to collect so much data about an individual that the sort of relationship between the small individual and the company is no longer balanced, so no longer fair, and you need to rebalance it. And I think this is the same notion, or at least that's a little bit my interpretation, intuition about the market environment, which is why maybe all of this becomes a little bit intertwined. And I find it very interesting that you're trying to, you know, get to the gist of this, yeah. But in terms of questions, I'm sorry, I was just wanting to ask as well, in terms of, I'm not sure if anyone mentioned this, but are there any like older examples, more historical examples of this term fairness in legislation? And if not, if you think that this explanation, that it really comes also from this information society overload, the changes related to the digital society, that this is why this became more prominent now. Yeah, that's my main question for now.
Thank you very much, Annika. So now it's time for me to explain how to take part in the conversation. So for the speakers, well, you are into the Zoom embedment, so you can raise your digital or virtual hand in order to answer or to ask a question or make a comment. And for the audience, you can paste your questions in the V2 shared chat. Feel free to make general comments or questions, or to address your question to one or to given speakers. As for the question of Annika, if no one is raising a hand, maybe I can give some background. I might not have all the, well, the entire answer. Be too much, sorry, not be too share. So I don't have the entire answer, but as for me, I'm doing research on the emergence of public utilities in the digital environment, or something that could be qualified as public utilities. I think there's a revival in a way of public utilities in the digital environment, and you could actually compare fairness to regulation that we have for liberalized industry, such as, well, I have a background in transport law. And in, for instance, in the railways where I worked before, you have this whole friend regime that makes part of a bigger picture of obligations. So you also have separation of activities, for instance, for the incumbent monopolist. So separation of activities that are regulated from other activities. Then you have behavioral obligations that are inspired by competitional remedies, but they go much, much beyond. And then you also have a regulatory authority that is there to substantiate and to make sure that the law is enforced. And you kind of have the same, even in terms of wording. You have this fair, non-discriminatory, transparent obligations there. You also have similar obligations for public sector information directive that then was turned into the Open Data Directive, where public sector bodies have some sort of friend obligations. So I think it's an interesting background to also compare, but I'm not sure that all the notions of fairness compare to this. Probably we have many different types. So I would be happy to give the floor to any of the speakers who would like to contribute to this discussion. We also have a question in the chat on health. It's a question from Geert Verhanen, my apologies, Verhaneman, especially to Inge and Damian. So she said she has the impression that the health data authorities included in the European Health Data Space Regulation proposal are indeed intended to act as intermediaries that have to assess fairness in requests for secondary use of health-related data. And then she reminds the fact that during COVID, we were actually unable to quickly gather data sufficiently high in quantity and quality. So as a result, authorities had to ensure that in future situations, data can be pulled faster, as long as it's for good reason. So she wonders whether experience in other sectors could inform this, although we know that big tech might be different from health. Well, all in all, are they so different? I can see that Damian and Inge, you both raised your hand. I think Damian, you were first. So yeah, the floor is yours. There are plenty of different questions, so you pick the one you like.
Yeah, well, maybe I'll try and do a little bit of each, but maybe try, at least maybe then I get one of them correct. I thought like maybe just as a like historic examples of fairness, just to begin with, to Annika's question. I mean, I think there's like notions of procedural fairness definitely within a public law setting. And then, you know, we could also just look at consumer law. I mean, there's been notion like the unfair terms regulations go back to the 90s. Yeah, so at the European level. And maybe that speaks a little bit like to open textured principles. That's kind of going to Bert's point about like the difficulty of implementing them. I mean, the law isn't completely foreign to those types of things. Yeah, I mean, if you look at the unfair terms regulations in a consumer context, you've got like the notion of good faith, for instance, which is very common to civil lawyers, very foreign to common lawyers, and was a bit of a problem in terms of implementation when it was transposed across. But like there you have a notion that kind of seemingly takes into account broad different things that need to be balanced. So I suppose maybe to a certain extent, it's actually translating other words that might be more suited or more familiar to national regimes, and having this kind of overall general fairness thing that's kind of legislated at the EU level as kind of a catch-all. So there's kind of like, what does it encompass and what doesn't it encompass? And that raises even more difficult questions when you start looking at, you know, different open textured notions in national law. So if you really want to start scratching your head, I think that's where you can kind of go. Outside of that, then, I mean, to Greet's question, that's a good one. I suppose like the difficulty, and I think you're probably not going to be surprised that I put it like this, it's kind of in determining what the good reasons are. I mean, the examples that come from, say, the areas that I'm more familiar with in terms of, like, you know, business to consumer services, kind of largely relate to kind of the add-on things that maybe the consumer hasn't anticipated. So things that go beyond what's necessary simply to provide the service that the individual has requested, and that actually being in the hands of the individual company or whatever to actually determine. So effectively, they figure out what fairness means. You know, you have frameworks that are essentially kind of categorized around the empowerment of individuals to make choices, when realistically speaking, it's extremely difficult given the asymmetries. I think that kind of goes to some of Inga's points as well. And that might be kind of a good way to segue over to Inga and leave her speak for a bit.
Thank you very much, Damian. Maybe I give the floor to Inga, and then Annika, you raised your hand and then lowered it. Do you intend to respond or?
Well, yeah, I mean, it's not so important, but I was just, thank you for the comment. And I do think it's quite interesting because in the end, I don't know, what has come up in conversations is also that, you know, in the end, consumers, because they're, you know, they're also in terms of this disproportionate relationship between the companies and the individual consumer. Some people have also raised in conversations here in Brussels, you know, a similar type of relationship between small businesses and large companies. So I think the analogy is quite interesting to explore if that's something that, you know, the legislator has to anyway decided to look into.
Thank you, Annika. Then Inga, the floor is yours.
Yeah, thanks. And thanks for the questions. They are really, really very interesting, and they go to some of the core points that I think are indeed up for discussion here. So to Bert's question, I think it's really indeed interesting to look at the perspective of what would happen if these legal frameworks did not have fairness in them. And there I agree with what Damian also was saying, that the fairness does not really is not really tailored at the digital setting, or it has not really started there. It's indeed a notion that we see very often in different types of legislations, where it's most used as an open norm that can be also be interpreted in a flexible way. So I think to one extent that is an advantage, because it means that the interpretation can move along with how markets evolve, how services evolve. But of course, it also creates questions in practice on how market players or how authorities have to interpret what is fair. So those are normally things that you cannot always clear up in legislation itself. So if I look at the Digital Markets Act, it indeed mentions fairness as one of its objectives, but it also has a very long list of concrete obligations that try to operationalize what fairness is according to the DMA. And in that sense, you could also see the use of fairness as a sort of overall objective that tries to give some leeway to authorities or to courts later on to interpret how certain obligations have to be applied, because not all of them will always be very clear upfront. But I think the most important thing for me is not only to look at fairness from each legislative instrument, but also to look at the more overall picture. It's sometimes misleading how fairness is used, because as we discussed, fairness can have different interpretations. So what is fair under one legal regime might not always align with what is fair under another legal regime. And a very siloed thinking or very siloed application of the law is, I think, really a problem there. So that is something that I think is really important to keep in mind. So how do different legal regimes interact with each other, and how can we create more clarity upfront on how market players should interpret the law when there is no full alignment. And fairness also plays a role there. And then to Griet's question, I think one of the things that came into my mind where I see a clear analogy with some of the things that I was discussing in the presentation is this trade-off between collective and individual interests that you see indeed in digital markets, in practices of big tech firms, but I think this will also be very relevant in the health context where the sharing of one's health data can tell something about other individuals, like your family, for instance, but it can be also used to for more collective purposes on what are effective treatment for certain diseases or what are risk factors that we see, which can then help to prevent certain diseases from occurring more often in the future. So this also, I think, raises the question, and I'm not sure if it's dealt with in this European health data space proposal, on how do you deal with this trade-off between the individual wanting to have control over how their health data is being used and when it is being shared. But there is also a lot of value that can be reaped from sharing health data that is more in the collective interest and where it might not always be practical to ask individual to consent or to have individual control over all of these forms of health data sharing. So this is, I think, another analogy between the digital and the health, where this trade-off between the individual interest and individual control and the collective interest comes into play.
Thank you very much, Inger. If you want to react one to the other, feel free to raise your hand. As for me, I have a provocative question on competent authorities, because we have a number of them, legacy ones, now we have new ones. And I'm a bit wondering about the rationale at the time when we started to have such authorities, especially regulatory ones, so authorities who have regulatory role as well. The aim was to have one authority, one instrument with one objective that should be not political, because we have authorities that are not elected and that are not directly accountable to the people. So that was back in the days, and now we have had more and more of those. And we still have more and more of those while they are expected to do much more. They're expected to make decisions which you could say are quite political sometimes. If you think of electronic communications law, if you think of personal data protection law, and even more so because now they're expected to cooperate in order to apply regulations which, as you mentioned, have at their hearts the need to balance different interests, and the law directly does not do it. So it's really for the authorities to do it. So my question, I don't know to what extent it's provocative, but are we still having the same, do we still want the same as the thing we wanted to have with those authorities in the 90s? The role we expect from them seems to me to be very different. I don't know who want to pick up on the question. Maybe Inger, if you feel like giving your thoughts on this.
Yeah, sure. No, it's a good point, because indeed the whole landscape is becoming more and more complex, and regulatory authorities also indeed get more legal regimes or different regulatory obligations to monitor. I'm not sure if this is really new. I would say that even in the 90s, maybe the legislation was not as complex, but I think still this trade-offs between different interests has always been there, but it is true that it's becoming more complex now. I don't have an answer to how this could be done in the ideal way, but I think at least it requires also authorities to exchange more with each other. And this is, I think, also is challenging the current way of enforcement, in the sense that many authorities indeed do this in a very siloed way. I mean, there is, of course, developments there, and there is In the UK and also in the Netherlands, there's now platforms that are starting up by the regulators where they mix the different authorities and really try to do this exchange of insights. But a lot of this, goes very slow. It takes a lot of time. Authorities have a different expertise, a different vocabulary very often. So it also takes time to understand each other and before they reach to a stage where they could do, for instance, a joint investigation or really discuss how they can help each other when they have to do this balancing where different regimes may come to a different outcome. So I think a lot of this will have to be worked out in practice. The only thing I could say is that to get there and to implement this in practice, having some formal protocols or some memoranda that allows authorities to actually talk each other without running into confidentiality issues is very important to at least start off this process.
Thank you very much, Inge. So we are approaching the end of our workshop. So Beth, I don't know if you've been raising your hand or it was just a mistake, but I was about to say if there is one last comment or remark, well, use the opportunity before we close the session. I don't see any hands raised. So then I hand the floor back to Natalie to close the session. Thank you very much all, and thank you in particular for this, I think, very fruitful roundtable.
Yes, thank you. It's my honor indeed.
Sorry,
it's my honor indeed. Annika, would like to intervene?
No, I'm sorry. I just need to go actually, but I could just write in the chat. I'm sorry. Thank you so much. I have to join for another meeting. Bye-bye.
Thanks to you. I was going to say, indeed, it's my honor to be able to close the session today. I would like to, on behalf of Charlotte and myself, as your moderators today, thank you all. Big thanks to our speakers. Still, at least for now, an online round of applause, but a big round of applause. It was very inspiring, and I would really like to, keep going this discussion to really continue. So I would like to invite all of you, please engage with us, please engage with our speakers, engage with the activities also of the BDVA Task Force 5. And special thanks again to Charlotte also for moderating with me here, to Bert and to Jaco and the BDVA team for facilitating this session today. So thank you, and let's keep the discussion going. Thank you so much.